Good evening. I'm John Lewis Wilson, an attorney in Lockport, New York. John Ross Wilson is here with me tonight. We're talking to you from our law office. The law offices of John Lewis Wilson at the historic National Centennial House, 111 Ontario Street here in Lockport, New York. This evening I'd like to talk a little bit, or more correctly, John Ross will talk to you a little bit about the issue of discrimination, the various types of discrimination, and when a discrimination claim may be appropriate. So let's begin with that, John Ross. What different types of discrimination are there?
Well, the first thing I want to say is New York State is what's called an at-will employment state. What that means is an employer can hire or fire you, deny you a promotion, or promote you for any reason or no reason whatsoever. It doesn't really matter if, it could be as simple as he likes you, doesn't like you, just is having a bad day. There's a couple exceptions to that. If you're a contract employee, for instance, you're a member of a union, so there's a collective bargaining agreement, then the employer has to abide by the terms of that agreement, of that contract. Other than that, there are also federal and state laws in place that prevent discrimination. And there's any number of ways that an employer can discriminate against someone based on race, on sex, on gender, in New York State on sexual orientation, religion, disability, age. So when clients come to see us, we sit down with them, talk to them about what has happened, and try to get a feel for whether or not their case falls into one of those categories. If the employer has taken some sort of adverse employment action, whether it's to fire someone, to fail to hire someone, to fail to promote someone, based on discriminating on one of those factors. Certainly sexual harassment, it's kind of considered an offshoot of gender discrimination, but is almost a separate sort of subset of employment discrimination law. Certainly if an employer, whether male or female, is making any sort of inappropriate remarks, any inappropriate advances that are sexual in nature, that are unwanted, all of that is covered by both federal and New York State law.
What would be the cost involved? Let's just assume for a moment that you determine a prospective client does have a situation that is actionable. Let's turn to the last point that you made about sexual harassment. Let's assume that a supervisor is approaching a female employee and making unwanted sexual advances, that there's not only language involved of a sexual nature, but also inappropriate touching. Would that be something, first of all, that would be actionable?
Well, based on that limited set of hypothetical facts, I would say yes. And again, we sit down with every potential client, listen to all the facts, ask any number of questions. I'm sure the client is going to have questions for us. That helps us to determine whether or not we feel you have a case. In this particular hypothetical, though, if there was some sort of inappropriate touching, certainly would seem as if there was a hostile work environment, a sexual harassment claim. The first thing you're going to want to do is to come in and set up a meeting with us. There's no fee for the initial consultation. We sit down, we'll chat, take anywhere from between 30 minutes to an hour usually to get all the necessary background information, and then we'll help you take the next step. In most cases, what we do is help the client to file a complaint either with the EEOC, which is the Equal Employment Opportunity Commission, a federal administrative body, or with the New York Division of Human Rights, which is New York State's anti-discrimination administrative body. In a situation where there's been some actual touching, some sexual contact, a client may also want to consider contacting the local police, because certainly harassment or sexual assault may be something that the police may want to look at in terms of filing criminal charges.
Ultimately, would the fee abide the outcome? That is, would the fee determine on be determined on whether or not there was a successful outcome?
Well, again, most of the cases we handle in terms of employment discrimination, we handle on a contingency fee basis. What that means is we only receive a fee in the event that we're able to settle the case or take the case successfully to judgment in front of whether it be a judge, administrative law judge, or a jury. Our standard contingency fee is 1/3 of whatever the client recovers. Any costs or fees that are associated with the case, the client is ultimately responsible for. That being said, there are some cases, and we certainly reserve the right to charge on an hourly rate basis. But that's something that, again, we take on a case-by-case basis depending on the facts of the case.
Thank you. I appreciate you taking your time this evening. Thank all of you. You can learn more about us online at www.johnwilsonlaw.com, or you can call us at area code 716-434-2010. Our Orleans County office at 9 South Main Street in Lindenville, New York, can be reached by telephone at 585-765-9481. Thank you for your attention.
Thanks.